Good afternoon, everyone. I'm Becca Murday, and on behalf of all of the Class Marshals of our graduating class of 2017, I'd like to welcome you to the final installment of the Last Lecture Series. As many of you know, the Last Lecture Series is a tradition at HLS where faculty and staff offer insight and advice to guide our reflections as this year's graduating class. Today, it is my honor to introduce our capstone speaker, Dean Martha Minow. Martha Minow, the Morgan and Helen Chu Dean and Professor of Law, has taught at Harvard Law School since 1981. During that time, her courses have spanned a wide variety and have included constitutional law, family law, international criminal justice, law and education, nonprofit organizations, and the public law workshop. An expert in human rights and advocacy for members of racial and religious minorities and for women, children, and persons with disabilities, Dean Minow also writes and teaches about privatization, military justice, and ethnic and religious conflict. In addition to publishing many scholarly articles and books, which shall go unnamed for the purposes of this introduction, Dean Minow serves on the Center for Strategic and International Studies Commission on Countering Violent Extremism. She served on the Independent International Commission Kosovo and helped to launch Reimagine Coexistence, a program of the UN High Commission of Refugees to promote peaceful development in post-conflict societies. Her 5-year partnership with the Federal Department of Education and the Center for Applied Special Technology worked to increase access to the curriculum for students with disabilities and resulted in many legislative initiatives to do so as well. In August of 2009, President Barack Obama nominated Minow to the board of the Legal Services Corporation, a bipartisan, government-sponsored organization that provides civil legal service to low-income Americans. The U.S. Senate confirmed her appointment, and she now serves as vice chair. She also co-chaired the Pro Bono Task Force. She serves as the inaugural chair of the Dean Steering Committee of the Association of American Law Schools and as a member of the American Bar Association on Diversity and Inclusion. She previously chaired the board of directors for the Revson Foundation and now serves on the board of the MacArthur Foundation. After completing her undergraduate studies at the University of Michigan, Minow received a master's degree in education from Harvard and her law degree from Yale. It's going so well. She clerked for Judge David Bazelon of the United States Court of Appeals for the D.C. Circuit, and then for Justice Thurgood Marshall on the Supreme Court of the United States. In addition to Dean Minow's many accomplishments, she has been a relentless positive force on campus during our 3 years at HLS. Not only is she unfailingly caring, she engages with tough issues with unparalleled grace and curiosity, all while ensuring that students succeed. Although it is her last year here as dean, and we will all be moving on to new adventures this spring, the impact she has had on this school and on each of us will endure far beyond when we leave this campus. For that reason, we are so honored to have her here today to deliver our final last lecture. Please join me in welcoming our dean, Martha Minow.
Thank you, Becca. That was so beautiful, and I just wish my parents were here to hear that because that was really lovely. It is an incredible honor for me to be invited to give a last lecture. I always worry that you hear too much from the dean, and unfortunately, you're going to hear from me again at commencement. So I promise what I'm going to talk about here is not what I will discuss at commencement, and that will be really short and fun, and you'll be distracted. So here we go. So thank you for this honor. For the last lecture, I don't think you want much law. I don't think you want a Socratic exchange. I don't think you want information. I think you're looking for something more like wisdom. Now, you'll be the judge of whether what I have to offer amounts to that, but I do have some insights from experience. Oscar Wilde had one of his characters in a play say, "Experience is merely the name we give to our mistakes." So in that spirit, I am going to describe to you some of my mistakes. Now, all of these are pre-deanship because we only have an hour. And I share these examples to you in hope of helping you make room for mistakes. And actually in hopes that you don't repeat the ones that I made. So the first one will take a little bit of time. It arose during some litigation. The great First Amendment expert Floyd Abrams called me up with a fascinating case. The son of an alleged mob boss named Patriarcha. This is amazing, right? Patriarcha, mob boss. It's almost Shakespearean. The son of the alleged mob boss sued the Federal Bureau of Investigation to halt distribution of surveillance logs and memoranda. The son said these were obtained illegally, and he obtained a restraining order from a court. That forbade the distribution and even any discussion of those logs. And knowing of the restraining order, nonetheless, a newspaper, the Providence Journal, printed a story based on the surveillance materials. The Federal District Court then held the editor-in-chief and the newspaper in contempt. Interesting to hold a newspaper in contempt. It really was an interesting case, pitting against each other privacy and the claims of the family, First Amendment and the questions of accountability, trying to hold the FBI accountable when it violated the law. But the case had two further aspects that made it especially compelling to me as a teacher and scholar of procedure. The case presented the first time in 25 years for a high-profile challenge to a rule that was notorious in leading to the imprisonment of Dr. Martin Luther King Jr. That rule is the collateral bar rule. It's a judge-made norm that says a court cannot hear a challenge to the merits of an action when someone is held in contempt if that person has violated the underlying court order. Only if they hold off on any violation and come to court first and say, is this legal, will the challenge be heard? Well, that's not what happened here. In Walker versus Birmingham, a majority of the United States Supreme Court enforced the contempt citations against individuals who had disobeyed a state court's temporary restraining order. And why did Dr. King and Ralph Abernathy and others disobey that order? Because they believed it was unconstitutional. Why did they not wait and go to court first? Because they had had too many experiences of the state and local courts actually doing injustice. Why did the Supreme Court nonetheless say they had no ability to challenge the order? The court said it was just applying a rule, a pre-existing rule, that prevents individuals from raising any challenge to a court order if they disobey it first. If you're a parent, you understand this. But as someone who really thought great injustice was done here, I found this decision outrageous. Moreover, the Supreme Court itself, in a subsequent opinion, held unconstitutional the ordinance that was relied on in that case, and therefore the temporary restraining order was predicated on an illegal ordinance. And nonetheless, Dr. King was sent to jail. In fact, it was those events that lay at the center of the civil rights struggle and the strategic choices that Dr. King made. The restraining order at issue forbade the plans for a nonviolent march to protest racial segregation and racially motivated violence in Birmingham, Alabama. What was the context there? Birmingham city ordinances segregated the use of drinking fountains, bathrooms, clothing store dressing rooms by race. The Supreme Court had already rejected racial segregation in public buses. How did Birmingham respond? By privatizing the bus company in order to keep the buses racially segregated. Now that I realize this is why I work on privatization. I'd forgotten that. The city laws segregated by race ambulances, police wagons, elevators, theaters, ballparks, jail cells, hospitals, hotels, and cemeteries. The law banned interracial marriage. A city rule deemed it a crime for African Americans and white people to play cards together, to play checkers or dice. When you have to have a law that says you can't play games together, it may say to you something else is going on here, something called apartheid When a federal court ordered the city to provide equal recreational facilities for blacks and whites, what did the city do? It closed all of its parks, its playgrounds, its swimming pools, and its golf courses. So despite the Supreme Court's decision in Brown versus Board of Education in 1954, as of 1963, all of Birmingham's schools were still racially segregated by order of the school board. The public library was open only to whites. Racial segregation was maintained through violence. The Ku Klux Klan brutally beat freedom riders and anyone who tried to actually integrate, under court order, the city's bus terminal. Birmingham had a nickname at that time, Bombingham, because so many homes and churches of African American leaders had been bombed. Segregation was also, of course, maintained by law. Lawyers, police, sheriffs, and judges enforced the racial segregation. And notable among the officials was Bull Connor, the public safety commissioner, who sent police dogs repeatedly against African Americans who were assembling peaceably and lawfully. Dr. King and others had worked with great discipline through church meetings and other discussions to plan a peaceful protest. They drew on the teachings, in part, of Mahatma Gandhi, as well as principles of Christian love. And the plans for a peaceful protest came to my mind last week because they were coordinated with Good Friday and Easter. That was the plan. The holiest days for Christians. Dr. King's group tried to obtain a public permit for the march, but learned in no uncertain terms that a permit would not be granted then or ever. And the city officials who learned of the plans about the march filed a complaint in court to try to stop it. The city argued that the parade ordinance properly prevented the marches, and the court issued an order directly forbidding the marches. And it was that order that Dr. King disobeyed. That order, by the way, that was issued ex parte, without the presence of any other Dr. King or his lawyers, and it was issued at 9 o'clock in the evening. The issuing judge was, of course, one of the good old boys, a member of the government that had implemented racial segregation and resisted federal court orders to dismantle it. King and his colleagues learned about the order the next day. They decided what to do. They debated, and in a prior effort to organize a civil rights struggle in Albany, Georgia, the same thing had happened. King had mobilized a peaceful protest plan, and then there was an injunctive order issued by a court. There, the protesters decided to abide by the court order and challenge it and appeal it, and in the meantime, weeks, months went by, the movement dissipated. So in Birmingham, King and his advisors agreed this would be different. They would violate the order. They made no effort to challenge it before Good Friday, and of course, such a challenge would have been fruitless, and there was other business to take care of. King, Ralph Abernathy, 60 others proceeded with the march as scheduled, and they were arrested. More were arrested 2 days later at the Easter Sunday march. The next day, on Monday, attorneys for King and the others appeared in court, and they sought to dissolve the restraining order. The court moved that the protesters should have to show why they should not be held in contempt. The judge found them guilty of contempt. The judge refused to consider the constitutionality of the restraining order because King and the others had disobeyed it first. And the judge said, collateral bar rule, you can't challenge the underlying issue. The violators received 5-day jail sentences and a fine, and 8 ministers, including Dr. King, remained as petitioners before the Supreme Court, but they, meantime, had to serve their jail time. The Supreme Court later took up this question of whether the parade ordinance was constitutional, and they struck it down. They said it was patently unconstitutional. But the court heard the contempt case first and reaffirmed the procedural order and said, sorry, we cannot consider whether or not this contempt citation was predicated on something unconstitutional. The court said the generality of the parade ordinance would unquestionably raise substantial constitutional questions. Nonetheless, can't be heard here. I found this outrageous. I learned about it when it happened. I'm not quite that old. I was not quite yet in law school. But then I went to law school. It's one of the reasons I went to law school. And the judges had said at the time, maybe if there's a transparently invalid order, maybe then people should be allowed to challenge it even after they've disobeyed it. And I thought, if ever there was a transparently invalid order, this is it. This is it. Refusing to grant a parade to people who are peacefully protesting in a community that has denied every possibility of civil rights here. So, one more thing. The Supreme Court in that case, in Walker versus Birmingham, dropped a footnote to a sentence referring to the reason why no man can be a judge in his own case, however exalted his station, however righteous his motives, and irrespective of his race, color, politics, or religion. Footnote. And the court cites an instance of an injunction disobeyed by a white man who tried to organize a campaign to interfere with court-ordered school desegregation in Tennessee. The court seemed to be warning that unless the civil rights protesters followed court orders, the civil rights opponents would not. Some of you may have heard of Dr. King's letter from a Birmingham jail. This is when he wrote it. This is when it happened. That's one of the pivotal documents of American history, pivotal document of the civil rights movement, in which I think memorably Dr. King talks about, if there isn't a higher law that questions what's going on here, then what's the point? And also, it's too late to wait. So Floyd Abrams calls me up and says, I know you hate the collateral bar rule. I hadn't known, it was well known that I hated the collateral bar rule, but I guess I talked about it a lot. I said, yes, I hate the collateral bar rule. He said, we have a case. Come and help challenge it. I was thrilled. I wrote, I swear, an eloquent, well-argued brief. It was fantastic. Attacking the application of the collateral bar rule, questioning its justifications, using the transparently invalid exception, and the case went up to the United States Supreme Court. What could be better, right? The Court of Appeals for the First Circuit had, in fact, ruled in favor of our client and said this was a transparently invalid order and declined to apply the collateral bar rule. I thought, this is ideal. The Supreme Court will finally overturn this horrible precedent. I was excited. I was thrilled. And then Floyd called me back. After the case was briefed, after it was argued, he called me up and said, I think we should dismiss the case. I said, Floyd? Dismiss the case? This is the case we've been waiting for forever. It's right before the court. My brief is really good. What are you talking about? That was my mistake. My mistake was arguing with Floyd Abrams, one of the greatest lawyers in America. But further, I didn't understand, and he educated me, why he thought we should dismiss the case. And he was right, and I was wrong, and I'm here to tell you. The patriarch family that had been behind the suit decided not to pursue the appeals. The district court decided not to ask the United States attorney to pursue the matter because he was also representing federal defendants in the underlying case. There was a conflict of interest. And so in order to have anybody on the other side to defend the restraining order and the contempt matter, the district court acted under a federal rule of criminal procedure and appointed a private attorney as the prosecuting attorney with full authority to prosecute the contempt matter. So far, so good. Floyd says, you know what? If you look at the rules, somebody appointed under that kind of terms has to seek approval from the Solicitor General of the United States before proceeding in the Supreme Court. And he didn't do that here. So we should dismiss the case. It's improvidently before the court. There's a procedural defect. It shouldn't be there. I am fuming. I've written this beautiful brief. It's the right moment to overturn this horrible precedent. And he was right. Because, as he pointed it out to me, I should have known this, Our client had won below. Our client had won in the First Circuit, and we were representing a client. And it was about the client, not about overturning that precedent. So I learned something. Even though I said, I don't want to seek dismissal, it's the first time we've had a shot to overturn Walker versus Birmingham and the injustice that it countenanced. Probably I said something less coherent and probably less appropriate for polite company. But altogether, this was my mistake. I was disappointed, but I learned. There are many lessons from this. One is remember you represent a client. That was an important lesson. Another was have a little bit of humility that maybe other people know more than you do. I'm just trying to tell Floyd Abrams how to litigate this case. There are many other things that I learned, but the next story I'm going to tell you suggests that there's not a clear lesson about procedure in that first case. Because after all, procedure was our friend. We dismissed the case using a procedural rule. And procedure was our enemy, the collateral bar rule. So story number 2, and I promise this one and a few others will be much briefer. I was a law clerk. As Becca mentioned, I had the great privilege for clerking for Justice Thurgood Marshall, my lifetime hero, unbelievable experience. Boy, do I have off-color stories to tell you. I'll just tell you one. This is not off-color, I promise. That waits drinks, but I promise I will do that if you want them. But I went for my interview for the clerkship, and I was really, really sick. You know, one of those horrible colds where stuff is coming out of your nose and no sound could come out of my mouth. And I called the clerks, and I said, could I possibly reschedule? Long pause. You don't reschedule with Justice Thurgood Marshall. So I show up. I have my tissues under one arm. I have, cough drops. I'm just a mess. He took one look at me, and he said, my daddy had a cure for what you have. You take quinine and whiskey, and you leave out the quinine. And he said, you want the job? I said, yes. And anyway, I did. Thank goodness. Anyway, one task that we had in that chambers was to read all of the petitions for certiorari. Right now, most of the justices are in a cert pool so that individual clerks read maybe 1 or 2 a week and write a long memo. In his chambers, we read every one of them. And so that meant every week I would read 30 to 40 cert petitions and write a memo. And you'd hear at that time everything was hard copy, not electronic. You'd hear the wheels of the cart coming down the corridor with another 30 or 40 cert petitions on topics I had never heard of. Remember, I went to Yale. So each one was like, oh my gosh, I never heard this, I never heard this, I never heard this. I learned a lot. It took me, the first time, it took me a week to write one cert petition. By the end, I was writing, 10 a day. It was quite a heady experience. One of them, though, I remember so distinctly, it was just a tragic, tragic case and very compelling on the facts, but the plaintiff had missed the filing deadline. So I wrote my memo, and I said, this is so compelling, we should really overlook this deadline. Well, this time, the judge, we called him judge, he didn't just mark up my memo. He came over and threw it on my desk. He says, we have to talk. Oh, what had I done wrong? He said, we need the rules. If we move the rules, they won't be there when we need them. Then he went on and he said, sometimes when he was a lawyer, their cases were weak on the substantive law, but they were strong on procedure. He said it's crucial to be a whiz in procedure. And he said if you're representing the relatively powerless party, you absolutely don't want the rules to change because you don't have the power to actually get the substantive law. As lead lawyer for the NAACP, he was a master of procedure. I've since learned from many others who worked with him and for him that this is one of his signature points. Justice Kagan told me she had the same experience when she was clerking for him. For me, it was sobering. And defending rules just because there were rules, even when they work a substantive injustice, collateral bar rule, all right? This is like my passion in life. It shouldn't happen. Dr. King, Walker versus Birmingham. But I learned something very important from Justice Marshall, and I learned something about lawyering and learning about the rules as an advocate and as an advocate for people who might lack the political clout to get the substantive law on their side. And yes, I decided to teach civil procedure when I became a law professor. And I have worked really hard to help students become whizzes in procedure. I confess I was surprised, but pleased, 2 weeks ago when an alum of HLS and of my Civ Pro class, who's now a national leader in banking and finance, has never been in court a day in his life, said that the focus on procedure has been the signature of his work and his success. I don't understand that, but I was thrilled to hear it. The tension between these two stories is something that I guess I continue to work on every day. We do need rules, and we need to respect them, and we need them particularly for those who don't have political power. But my goodness, there are rules that their applications are terribly unfair, and we shouldn't have rules that prevent their challenge. This is why I'm still hard at work on a book on what role forgiveness should play in the law. Some of you have heard me talk about that. I look forward to turning to that full time. It seems more important than ever, although I'm going to add a new section of the book about what's unforgivable, I think. Next mistake. This one takes me to time before law school. There was life, even for me, before law school. I had a chance during my graduate studies to assist the people who brought us Sesame Street. How many of you watched Sesame Street growing up? Okay. So, look, I love Sesame Street. It was a thrill to be able to work with the Children's Television Workshop people. I learned so many great things from them. For example, they have a process for working through the creative idea generating phase of a project that they call the yes day and the no day. So day one is just yes, brainstorm, brainstorm. No one can say no. No one can say that's a bad idea, it won't work. And then a different day altogether. You take all the ideas and you go through one by one. I have found this to be an incredibly helpful tip. You don't cut off the creative process with the but, which is really important and not what lawyers do, right? And so I commend that to you. I give that to you as a gift. It was a gift to me. The project I was invited to join them on was to create a new show. And to create a new show that addressed really curiosity and science. And I was in graduate school in education and worked on child development, and this was a great moment to learn about learning and to immerse in the research and so forth, and I had really just a tremendous experience. Later, the show was actually launched. I don't know if any of you ever saw this show. It's called 3-2-1 Contact. Yeah, a few people heard of that. It wasn't as successful, but it went on for 8 years. So several teams of graduate students worked on alternative proposals for a new show. My team had on it a former actor, several teachers, a finance person, a psychologist, and me. Now, I was much the youngest. Imagine me as a young person. It can be done. I started grad school when I was 20, and everybody else was quite a bit older. I was no doubt the least qualified person in the group, but nonetheless, I found myself leading meetings. Like I'd set up the meetings, and I'd organize them, and then I'd write up in between the meetings what we'd done, and I moved it along, and so it was with some real pride that I turned in our proposal that I had written to the producers of Sesame Street, and we found out we were the first ones to turn in the proposal of all the teams. This was a mistake. It actually gave rise to a lesson. The producers and their academic collaborators sat me down, and they engaged me in what, in retrospect, I realized was a Socratic dialogue. I didn't really know that at the time. Their questions were something like this: why do you think it's positive to be the first one to hand in a proposal? I muttered something about timeliness and eagerness or something. They said, are there any values besides speed in doing work? Okay. I thought, quality? They said, yeah. Any others? That I was stumped. I couldn't possibly think. What else could there be? And again, it was a point about process. They taught me that ensuring that every participant in the group was included and felt included was as important as the product. That everyone had ownership of it. That everyone had time to think it through. I had not considered any of that. It was a life lesson, a real lesson. I think about it all the time. That was the lesson foremost in my mind when then Dean Elena Kagan asked me to lead a curricular reform project here. I did not leap at the chance. I said no 3 times. I said no because the world is littered with the carcasses of failed curricular reforms. I said no because my very first year on the faculty here, I watched faculty meetings treat a very thorough and well-developed curricular reform report written by Professor Frank Michelman as target practice. And by the end of the year, we had not only not adopted any curricular reform, you couldn't even find the report. It was so full of bullet holes. Justice Kagan then and now had persuasive powers. I ended up leading a curricular reform, but I said yes on 3 conditions. 1, I said no report. I didn't want to repeat what I'd seen. I said lots of meetings, lots of process. That was condition 1. Second condition, I said it has to be one of your top 3 priorities as dean. You have to say, I'm going to be at every one of these meetings, and it really matters to me. After all, she'd persuaded me to take this up. I was going to make her suffer with me. And third, I said there has to be a lot of food. And that's what happened, and we actually approved a curricular reform unanimously. It was a remarkable experience and process. Partly scaring people to death that we're going to have another meeting. I mean, if I swear to God, if several members of the faculty, if they saw me one more time, even with my food, they'd say, forget it. It also helped, here's another tip I learned from Justice Kagan. We had a very radical proposal. I guess you're about to graduate, so I can tell you this. We had a very radical proposal that obviously did not get adopted. To change the first year to squish together all the common law subjects into one and make it rather short, contracts, torts, and property. And, you know, I'm from Chicago. I'm not a bad politician. I said, this is not going to happen to Dean Kagan. She said, keep it on the table. I said, why? She said, keep it on the table. It'll scare them. And it is true that the reforms that we made, while contentious, shave off 1 credit from each of those classes, move them from 5 to 4, even though I had various people. One of them, dare I tell you, Senator Elizabeth Warren, then professor, said, basically, God created the 5-credit contracts class. Can't be changed. It was fun. But it was true. It really helped to have on the table, well, we might just smush all these classes into one. And, you know, so it worked very, very well. We had the curricular reform. It was unanimously adopted. But I do believe it was the process. It was the process. Everyone had been heard, and everybody didn't want any more process. I'm sure that there is a time and place for process, but done thoughtfully, my experience is that it more often helps than hurts. And that's something that I learned back in those days working with the Children's Television Workshop. Final experience. As Becca said, some of my work in the past has dealt with disability issues, the rights of people with disabilities, and some of my research and advocacy has focused in this field. So I was really thrilled when a nonprofit group, the Center for Applied Special Technology, long name, nice abbreviation, CAST, when they asked me to join as they bid for a contract with the federal government to implement what was then a brand new law that called for access to the general curriculum for kids with disabilities. I was thrilled. It looked like real work. It looked like something I knew something about. I'd written a lot about disability law, and I became the director of policy. And I felt like, okay, I can do something here. I know something about disability law, and I look forward to what I thought would be a task of educating school administrators and teachers about what the law required, and we would just implement the law, and that would be great. I show up the first day at the job, and I discovered that was not the assignment. The assignment was not to educate teachers and administrators, but instead to tap into what was then the emerging digital revolution. Because what the CAS folks knew before almost anybody else is that if you digitize teaching materials, you can pretty quickly make them read aloud. You can pretty quickly change the font and have them very big. You can integrate them with another program that can interpolate an interactive animated creatures who can pause and say, do you have a question? And they designed these wonderful resources. Indeed, a child with physical disabilities who could signal with an eye blink could open them all up. It was really wonderful. Just one problem. It violated the copyright law to do all of this. So day one, I discover everything that I knew was irrelevant, and the one course, one of many, I never took at law school because you know where I went, was copyright. I knew nothing. So I busily conferred with experts here and elsewhere, and they read the law, which was a good thing to do, to actually look at the statute, which had an exemption for persons with visual impairments, which seemed like, oh, that's really great, except lots of people with disabilities have other impairments. Learning disabilities, not covered. Quadriplegia, not covered. So this, we talked about, could we try to interpret creatively? No, we couldn't. What could we do? So leaders of the Berkman Center, now Berkman Klein Center, graciously took me in, and they said, contract law. I said, what? That's not what I did in contract law. They said, you could actually draft contracts to get the potential suers, the plaintiffs who might sue you for copyright violation, to agree. You could pay them something, or they could just agree not to sue you, and that would be great. And it turns out there were only 5 major publishers of K through 12 textbooks. You could actually do this. This is something that was feasible. Seemed like a great idea. Why don't we just bring them together? Well, turns out that's an antitrust problem, another course I knew nothing about. So I go to the antitrust experts on the faculty. I say, what do? We would like to have a meeting, or I'd like to at least talk with these people, but they're all in competition with each other. It violates the law. Bless his heart, Einar Elhag said, there's an exemption from the conspiracy element of antitrust if it's an educational gathering. I happen to have an educational institution right here. We invited the publishers of the 5 leading publishing firms to come here and introduce them to this wondrous technology. And because we had business school types, we gave them business models about why it'd be good for their businesses and how they could maybe open up the textbook industry to everybody, even the bored kids, and that it might actually be better for learning for everyone. And I can only tell you that it was my colleagues who came to the rescue. It was an amazing meeting, because apparently, we heard later from the Department of Education, they had given us this contract with the assumption it was going to fail. And it didn't fail. That meeting was a success, and it started a whole different conversation. And finally, here was something that drew on my own research, because I had argued that accommodations for persons with disability can benefit everyone. Curb cuts can benefit people who are pushing a stroller, as well as someone who uses a wheelchair. And assisting a student with hearing impairments to participate in class actually helps other students learn from that student, as well as helping that student. So that was what I had argued before, and now we had digital tools that could make learning interesting and engaging for all students and recognize the individualized learning styles for each. We had lots of problems how to proceed, but that meeting was a turning point, and from that meeting on, we developed first voluntary standards, and then they were enacted into law about how every producer of teaching materials should make their materials available to be digitized. And the world changed. Now, it's hard to believe. This is a different time and place. The federal government actually unrequested gave more money to the project. And now digital teaching materials are familiar, even though the full vision awaits. There were many lessons for me. One was in humility. I thought I was such an expert. I knew nothing that was relevant, to put it mildly. Another was gratitude for the generosity of so many people. Another was wonderment at the many tools of law. Wow, here's the pizza. Just in time. I will wrap up pretty soon. And I guess if there's a lesson here, it is you may think you know what you want to do. Be focused, be flexible. The best way for me to serve students with disability was to learn copyright law and antitrust law and actually do something about business strategy at the same time. The last thing on earth I thought it was going to be relevant, but it was really important. So I also learned, of course, about the difficulties of working with federal and state agencies, the impossibility of working with many different advocacy groups who disagreed about everything, how important it is to be creative and flexible. So my many mistakes. There's some common themes and there's some tensions here. One is that process matters, but it shouldn't trump substance, at least not all the time, except sometimes, so that's a struggle. Another is that focus matters. Eyes on the prize, but so does flexibility. Another is that serving others matters, especially if you're a lawyer, even more than serving abstract ideals, but ideals matter too. But maybe the most important lesson for me was that mistakes are a gift. The mistakes that I've made, these and others, have been the touchstones for learning. More than any success that I've ever had. I've learned much, much more from mistakes. Research shows that the brain reacts in 0.1 seconds to things that resulted in past errors. It sends out a kind of warning signal that cautions against repeating the same mistake. Mistakes are how we learn. Other people have made this point even better than I have. Donald Rumsfeld, when he was Secretary of Defense under Presidents Ford, later President George W. Bush, he said, "Visit with predecessors from previous administrations. They know the ropes and can help you see around the corners. Try to make original mistakes rather than needlessly repeating theirs." Particularly interesting since he had the same job twice under two administrations. I always wondered, did he go visit himself? I don't know. But another person, currently the National Economic Council advisor, Gary Cohn, said, "Every time you get a new job," this may be the most important thing I tell you today, every time you get a new job, he said, new location, you have an amazing opportunity in front of you. You get to play dumb for as long as people allow you to play dumb. You get to ask all the dumb questions, you get to ask multiple people the dumb questions, and you get to make mistakes. This is really good advice to all of you as you start new posts, and I guess to me too, as I start a new chapter, and to him too, as he has a new job. You're not people who have made a lot of mistakes in your life. And you're not people who actually like to fail. And I am urging you to think about that. And so for here, I find the great writer Neil Gaiman. Any Neil Gaiman fans here? Okay. Author of fantasy and a fantastic author. He said, and I quote him, "I hope that in this year to come, you make mistakes. Because if you are making mistakes, then you are making new things, trying new things, learning, living, pushing yourself, changing the world. You're doing things you've never done before, and more importantly, you're doing something." Two more quotes and I'm done. Bono. Bono said, "My heroes are the ones who survived doing it wrong, who made mistakes but recovered from them." And the artist Vincent van Gogh, he said, "Even the knowledge of my own fallibility cannot keep me from making mistakes." Think about that. Only when I fall do I get up again. I wish you many great falls and many great standing up again. I wish you not just great success and happiness, but also great mistakes. Thank you for bearing with me with my many mistakes and for inviting me here today.